It's very satisfying to help people. I just can't imagine a better job.
Well, good afternoon, everyone. Michael Ettinger here from Ettinger Law Firm. And this is our last in a series of 6 Zoomside chats. Today, we're going to go over the top 10 reasons to plan your estate. I think if you're on the 6th chat, you probably know who I am by now, so I won't take you through all the preliminaries. I think we can go right to the shared screen, which you got a copy of with a confirmation for this meeting. So here we are. There I am in the middle, my lovely wife and law partner, Suzanne Ettinger, to my left, the rest of our staff here at Ettinger Law Firm. Somebody's asking a question. Well, Anonymous asked the question here, can a successor trustee change the terms of the MAPT after I'm deceased? No, they cannot. There we go. Takes care of that. Ettinger Law Firm, our practice is limited to trusts and estates, wills and probate, mostly estate tax saving strategies, Medicaid applications, Medicaid trusts, basically limited to elder law, estate planning, and our offices are around the state, 14 offices. If you have any questions while I'm speaking, please feel free to type them in at the Q&A at your bottom. I'll answer them at the end. So what are the 10 reasons why you want an elder law estate plan? Well, number 1, we want to control who gets the assets after I'm gone. Now, of course, a will can do that, but a trust can do that as well without having to go to a probate court proceeding. If you don't have a plan, the state has a statute that says where it goes. For example, if you have a wife and children, roughly half to your wife, half to your children. If they're minors, the court will have to appoint a legal guardian to manage the money for them and pay it over to them when they're age 18, ready or not. Here I come, so to speak, because that's the age of majority. So if you have children, you probably want to leave whatever you're leaving to them in trust till they're maybe older, 30, 35, put somebody more responsible in charge, give the responsible person the right to use the money for their health, education, maintenance, and support. And whatever they don't use, they turn over at the appointed age. You can pick whatever age you want. You could say something like, give them 20% when they're 30, half of what's left at 35, the rest at 40. Meantime, the rest of the money is available to them, but the trustee decides how and when to distribute it. So you're going to get the assets to whom you want, when you want, the way you want, with the least amount of taxes and legal fees possible. That's basically our goal in estate planning. So when you want, as I said, you can have a delayed distribution. Some people will say, give them 20% when I die, whenever that is, half the remainder after 5 years after I die, the rest after 10 years. And you could put a cap age on that. You could say, well, 20% when I die, half of what's left after 5 years, the rest after 10 years. But once they hit age 65, regardless, they get the whole thing. So you can put a cap age and say it all pays out at 65 regardless. Any age you can pick, regardless of what the distribution was. And as I say, so it goes to whom you want, when you want, the way you want, with the least amount of taxes and legal fees possible. So naturally, we want to control the legacy that we leave. It's natural. Reason 2 is giving it back, paying it forward. Giving back, paying it forward. Now, in my experience, it's remarkable how few people give back to the institutions and whether it be academic or religious or otherwise, that helped made them who they are. A few years ago, I was asked to contribute to, they were doing a donor wall at my alma mater, which was McGill University in Montreal. Some of you know I'm born and raised in Canada. I've been here for over 40 years, but that's where I was raised. I'm a dual citizen. I made a significant donation to the donor wall at the highest level, in recognition of the fact that much of my success today is based on the quality of the education I received at McGill and the quality of professors we had there. But I have to say, I was pretty surprised at how many successful lawyers I knew gave little or nothing back to the school that made them what they are. So I don't think it's a bad idea. You know, consider your alma mater, or if you've been, if your life has been significantly enriched by your temple or your church or other mosque, consider maybe leaving something to that design. I think it's just overlooked. People just overlook it. So you can give back to your alma mater place of worship. Keep in mind that sometimes children don't need the money. They're very well off, maybe much more well off than parents, or they don't deserve the money. And we all know that. An interesting story I'll share with you. Ann Landers, may she rest in peace. We all grew up with her and we knew her to be a pretty wise, sagacious woman. She once wrote that her most requested column, which she repeated 7 times in her career, her most requested column was the one about inheritances. And what she said was, an inheritance is not an expectation, it's a gift. And if you don't deserve it, don't expect it. So a lot of people think they have it coming to them, but they don't do anything to keep in touch with the parent or to show any care or concern with the parent's well-being. So maybe there won't be anything there for them at the end. Again, if you just joined us, if you have a question, go ahead, type it at the bottom, and I'll answer all the questions at the end. Thank you. Reason number 3, showing you care. Well, what's that about? Well, it's the concept of stewardship. You know, when you take the time to plan your estate, and you're careful, and you're deliberate, and you prepare all the documents, the trusts avoid probate and keep control on the family and avoid guardianship proceedings, the elder law power of attorney so they can move assets if you become disabled, health proxy and living will, maybe setting up trust for your children to protect the inheritance from their divorces and creditors and pass by blood instead of by marriage. What are you doing? You're setting an example of how they should handle their affairs. It's a concept of stewardship, you know, management of one's affairs. As I say, it sends a powerful message, and it'll be reflected in not only how they plan, but how they spend the money. If they see how careful you were with it, they're likely to be more careful with it themselves. So you'll be an example to them. This is interesting. I had a case in yesterday. The client, I'll just share this story with you. And the client came in and he said, you know, I wasn't really sure if I should come, but, you know, I thought, well, okay, maybe I'll get a second opinion. So he gave me his plan. He was well off, you know, had a, you know, maybe about $6 million estate with 3 children. And I noticed a few things. One was he had a house in Florida, but the lawyer prepared wills, 2 wills. And so I explained to him, well, first off, those wills are going to have to be probated 3 times. Once when the first spouse dies, because you have a taxable estate, so you have to create a trust in the will for the first spouse. Twice on the second death, because on the second death, we have to probate in New York and in Florida for the second property. The Florida property would pass to the survivor, but won't pass to the kids without a probate. So now we have 3 probates. Now, I also noticed they had nothing to keep the assets in the blood. They didn't set up trust for the children. So nothing to protect the children's inheritance, $2 million if they get divorced. Nothing to protect them if they get sued. And if they die, it could go to their spouses and then whoever the spouse marries later on. There was nothing to keep it in the bloodline. And then I looked at his assets and I saw he had a lot of IRA money. Who's the beneficiaries? Well, the spouse and the children. I said, well, you have a plan here on paper to save estate taxes, but your assets are not designed to flow in the right way to save the estate taxes. In other words, if you might have all this wonderful paperwork, but his assets said I leave everything to my spouse. So even though the will would set up a credit shelter and save taxes, nothing was going by the will. It was always all going by beneficiary designation, the net effect of which was to leave all the money in the surviving spouse's estate and affect no tax savings because we didn't have the husband had a trust and a will, but he had no structure in his assets to use that trust. And I explained all this to him. And by the time we were done, he was very happy that he came to see us. And what I told him was, and it was a conclusion I reached, in the world we live in today, it's very hard to find two things in the same place. Somebody who's competent and somebody who cares. There's people who care and aren't competent. There's people who are competent and don't care. But to find both is like a gem. And if you can find it, hold on to it. It's very valuable because this is what everybody needs. Not somebody who's just competent, but somebody who cares enough, for example, to make sure the plan that was set up is actually going to work. Takes time with the assets, changes the beneficiaries, make sure it goes where it should go, goes to the trust if it should go there, should go to the children's trust if it should go there. That's the caring part. And unfortunately, I think the caring is a little bit in shorter supply than it used to be. So we have this concept of stewardship. Reason 4, save your heirs time and money, not to mention keeping the family together. So we save the heirs taxes. We do that by setting up 2 trusts. Of course, you need a spouse for this, one for the husband, one for the wife. You're both in charge of both trusts. Do whatever you want with the money, buy, sell, trade, spend. But when husband dies, let's say husband dies first, okay? His money doesn't go to the spouse. It stays in his trust up to the amount of the exemption. How much is the exemption? Well, the federal exemption is currently 11.7 million. We're in the Trump era in terms of estate taxes. But of course, we all know there's a new administration, and many of us know they proposed to lower the 11.7 million to 3.5 million. Ouch. Well, that means unless you do some planning, you're going to pay taxes on anything over 3.5 million, and the new tax rate will start at 45% and go up to 65%. Probably not too many people hit the 65%, but figure about half of the amount over 3.5 million will go to taxes. If you have a spouse and you set up 2 trusts, one for the husband, one for the wife, they can each claim a $3.5 billion exemption under the new rules, past $7 million tax-free. When do you have to do this? Before the first spouse dies, because you have to have their trust in place before they die. Now, these trusts are revocable trusts. Husband and wife, joint trustees on the husband's trust, but it uses his Social Security number. Wife and husband, both trustees on her trust, but uses her Social Security number. These 2 trusts will allow you to pass double tax-free to the heirs, but it has to be set up on the first death. The New York estate tax exemption is now 5.93 million. What is New York State going to do if the feds lower it to 3.5 million? Mark my words, they're also going to lower it to 3.5 million. That's what I expect. But currently 5.93 million. And if you read my column in the newspaper and my alert, my law letter, you'll know that there's a fiscal cliff in New York. Unlike the feds, if you go over the limit in New York of 5.93 million, they tax the whole estate. For example, let's say you're over by a couple 100,000, let's say 6.2 million. That's about 500,000 in tax on an estate like that. So you want to save the heirs taxes, set it up, and then hopefully you're with a law firm that's tracking this and will keep you advised of law changes. So keep an eye on what I'm writing, because I will be able to tell you when things are heating up. Right now, we're not sure what's going to happen. But if you're in a position to move money, it's a great time to do it. Can't hurt, can only help. The estate planning saves heirs legal fees because there's no court proceeding. Court proceedings are time consuming and expensive, either for guardianship if you become disabled and you don't have a plan, or for probate on death, which can take years. We have probates in the office that are running for years with no end in sight, so that they become fairly costly. And it saves the heirs time. Now, if you watch my seminar, my weekly seminar, you'll know I'm very big on saving the heirs time. I would like to settle your estate in 2 months instead of 2 years. Why? Well, obviously, you know, time is money. The sooner you settle it, the better it is for everybody, the less expensive. They get the money to use, but it aids in the grieving process instead of 2 years in court. You know, it's a constant reminder of the loss. they get on with their lives and they move forward. But if you've been listening to me on my weekly seminar, there's a social cost to probate. Probate breaks up families. You notice after the will is settled, a lot of times the brothers and sisters, they never talk to each other again. Well, they've just been in business for a couple of years. Doesn't go well. I don't want to put your family and business together. Leads to bickering and bitterness and recriminations. So, I've settled my parents' estate with my brother. My spouse has settled her parents' estate. I know exactly the types of things that go on. I have, of course, all our clients' experiences. And I think you'll all agree with me. The sooner you can settle it, get everybody their money, have them go their separate ways, the better it's going to be for your family and everybody concerned. That's a given. So I want to save the heirs time. I'm very big on settling the estate quickly. Move on. Reason 5, protect your assets from long-term care costs. So we know, let's talk about Medicare and Medicaid. People get them confused. Medicare is a government-sponsored health insurance program. Everybody's eligible at age 65, but Medicare pays for skilled care. Skilled care is nurses, doctors, hospitals. Medicaid is different. Medicaid pays for custodial care, like help with washing, dressing, going to the bathroom, that sort of thing, feeding, showering. So while Medicare, everybody gets at 65, regardless of how well off you are, Medicaid is different. Medicaid is called a needs-based program. You have to need it. And when they say need, they mean 2 things. 1, you have to actually be unable to handle any 2 or more of the activities of daily living, which are, as I said, washing, dressing, toileting, transferring, feeding, etc. So you have to need the benefit because you're unable to handle any 2 or more of the activities of daily living, and you have to need it financially. If you have your own money, you're not eligible for Medicaid until you spend down your own money till you get to the Medicaid limits. What are those? Well, the maximum, if you have a spouse, the maximum a spouse can keep is $130,000. That's the maximum. You can't always get that much. And if you're single, the maximum you're allowed to keep is about $16,000. So if you need custodial care and you have over those amounts, you have to spend down until you get down to the limits, unless you were smart enough to plan ahead a few years and set up a trust to shelter your assets so they're not in your name, they don't count. So we want to avoid the spend down by setting up a trust, which a trust you pay for once. And a lot of people can't afford long-term care insurance who could afford a trust, because long-term care insurance you pay every year. The trust you pay it's one and done. So if you can't afford long-term care insurance, or you get turned down for financial reasons, you can't afford it, or you get turned down, I should say, for medical reasons, or you're too old, over 70, it's prohibitive. You want to look at this Medicaid Asset Protection Trust, protect your home and life savings. So we like this Medicaid Asset Protection Trust, the MAP. It allows you to have your cake and eat it too. In other words, you have the use and enjoyment of the assets, but you're not technically the owner, so they can't come and take it away from you, subject to the 5-year look back. Now, we know you can't transfer all your assets a day before you have to go to nursing home and say, I'm here, take me, I don't have anything, because they can look back up to 5 years. So you want to do this ahead of time. If you don't make the 5 years, 4 years go by, you need care, you only have to pay for the 1 year that's left. That's why it always pays to get started. Some of you may know, we have a new look back period. It's supposed to start on July 1. Now they pushed it off again to January 1, 2022. So you're going to be okay for a while. But starting January 1, 2022, there'll be a 2.5-year look back for home care. 5 years for facility care, nursing home, 2.5 years for home care. Get your Medicaid Asset Protection Trust in place now. You can learn more about it in my weekly seminar tomorrow, which I'll tell you about later, how to register. But I'll go into detail about the Medicaid Asset Protection Trust. Bottom line is very flexible. The money is there if you need it. You have use and enjoyment of it. You keep your exemptions on your house. You can sell the house, buy a condo, you can trade your portfolio. You can change who the trustee is. You can change who you leave it to. You can gift money out. These things, if they're done properly, will not cause any change in your lifestyle. Still get all your income from all sources. I urge you to look more into the Medicaid Asset Protection Trust, either by watching my seminar tomorrow, or you can go to my website, trustlaw.com. Look under practice areas and read about the Medicaid Trust. There's a couple of articles on it right there under practice areas. So we want to protect our assets from the cost of long-term care, running maybe $18,000, $20,000 a month in some of our areas now. That starts to affect even the well-to-do. Reason 6, protect the inheritance from children's divorces, lawsuits, and creditors. I'm amazed how many people have substantial estates in the many millions. I would say the vast majority of them leave it to their children in equal shares. No plan to protect the children inheritance if they get divorced, no plan if they get sued, and no plan to, we'll see later, to keep it in the blood. But when you're leaving, I like the number 500,000. If you're leaving a gift of 500,000 or more, doesn't it make sense to protect it from a divorce rate at 50%? Now, for those of you who know a little bit of the law, you know that when somebody gets an inheritance, if you get divorced, is not subject to be shared in a divorce, provided the inheritance is kept separate. You have to keep it separate. Now, it's not always easy to do because husband or wife gets a check from the lawyer. Mom died. Here's a check for 500,000. Now, is it going to go well if they tell their spouse, well, I want to keep this in my personal account? Doesn't always go well. How about setting up a trust for them? And now they say, I got 500,000 from mom. She set up a trust for me. Obviously, now the son or daughter, they don't have to take the heat. You did it for them. It's protected to get divorced or sued. Anybody can cause a personal injury. They could have a bankruptcy. They can have very large medical bills over and above what their insurance pays. They can lose their livelihood or business. Some people did because of COVID-19. Look, we all know things happen to people, even good people, even careful people. So it does make sense. Set up an inheritance protection trust. Put your son Bobby in charge. He can do whatever he wants with the money. He could buy, sell, trade. He could spend the whole thing, but protect it if he gets divorced or sued. That makes sense. And keep it in the bloodline. So I'll tell you a story. A few years ago, a fellow came to see me in my White Plains office, and he told me, we'll call him Mr. Smith, okay? That wasn't his name, obviously, but Mr. Smith comes in, and he's about 72, and he introduces me to his fiance. She's 55 years old, and turns out he wants to leave his estate half to his daughter and half to his fiance. So go find Mr. Smith, come back in a few weeks, and we'll execute the documents. Well, he comes back a few weeks later with his fiance and another woman. I said, now, Mr. Smith, who's this other woman? He goes, oh, that's my lawyer. I said, really? I thought I was your lawyer. He said, well, a man can have two lawyers, can't he? I said, well, yes, he can, Mr. Smith, but not at this office. So, long story short, I showed him the door. I wasn't happy with that surprise. I got a call the next day from the daughter who told me that her mother's turning over in her grave. The estate, which was well over $1 million, was all her mother's side. Her mother died first, left it to her husband. And she said, I've been his daughter for 51 years. He meets this woman 6 weeks ago, and he wants to leave it half to her, half to me. This is outrageous. I said, I'm sorry, but he can do what he wants. He's legally competent. Oh, by the way, who was the other woman? It turns out it was his fiance's cousin, the lawyer, to come make sure that her half was nailed down tight. So there you go. We don't want that to happen. So we use the inheritance protection trust so that it doesn't go the standard, goes to my son. Well, let me go back. What is a standard distribution? To my son, Bobby, but if Bobby dies before me, his share to his children. I'm sure this sounds familiar. Everybody who says, if my son dies before me, I want it to go to my grandkids. There they are, right in the picture at the bottom of the screen. But we know most children survive their parents. So let's say Bobby doesn't die before you. You die and Bobby gets your $500,000. Now, what if Bobby dies 3 years later? Does your will have any effect? Of course not. Your estate is closed. They already got the money. So where's it going to go if he dies? It's going to go to his wife. Can she get remarried? Share your $500,000 with a complete stranger? She probably will. People live 32 years longer than they did a century ago. So people are putting in a Bobby trust. They say, Bobby, I'm putting in a trust. I'm putting you in charge. You can do whatever you want with the money. But when you die, whatever you didn't spend goes to your kids, my grandkids. Whatever doesn't have kids, then it goes to the, his brother and sister, nieces and nephews, but always passes by blood instead of by marriage. Keeps your money in your family for generations to come. You're fond of your son-in-law or daughter-in-law? Fine. Say when Bobby dies, if he's still married to Mary and they're living together, keep half in trust for Mary, give her the income for life, give half to the grandkids at that time, keep the other half in trust for Mary, give her the income for life, and on her death, give the second half to the grandkids. So if she gets remarried, husband number 2 won't get it because it's left in a trust for her, income only. The grandkids will get a second installment when she dies. Reason 8, protects you if you become disabled. Now, wills, and here's the major reason why trusts have become so popular since around 1990 when I started doing trusts, which is the beginning of this living trust revolution. Now it's about 30 years old. The number one reason trusts become so popular is because wills only take effect at death and trust takes effect while you're living. Why is that important? Because with everybody living so much longer due to advances in medical science and better nutrition, today about half of all people become disabled before they die. Well, if you become disabled, does the will help you? Of course not. You don't have a plan for disability, and you risk one of the worst things that can happen to you legally, a guardianship proceeding where a judge takes over control of your affairs and appoints a stranger to handle your affairs, which stranger it may not have the same interests as your family. Sometimes we like to say here at Ettinger Law Firm, planning for disability is more important than planning for death. And that's because planning for disability is for you. Planning for death is for them. You come first. So we want to set up a revocable trust. A living trust takes effect while you're living. We know that half of all people eventually become disabled. Want to avoid the risk of guardianship proceedings. And by the way, if you ever get into a guardianship, good luck trying to get your assets back, because once they get control, it's very, very hard to get out. The thing is to prevent yourself from getting in. But the trust avoids a guardianship because a trust has your assets in it. It says who takes over if you become disabled. And the court has no control over your trust. So you're going to get the person you choose. Could be 2 people acting together. And what are they going to do if you have an accident or illness, a disability? They're going to come to Ettinger Law Firm. They're going to say, well, you prepared mom's plan or dad's plan 25 years ago. Now mom or dad needs care at home or in a facility. What do we do? Well, you have all the powers under the trust to do whatever needs to be done. You don't have to go and ask a court for permission. You don't have to worry they're going to appoint somebody else as the guardian. Act immediately and do whatever the law allows. These trusts and these power of attorneys that we use have all the flexibility in the world. Our documents are designed to be extremely practical. I'll give you an example. The majority of powers of attorney that people bring into my office, vast majority, will say, I appoint my spouse first and my daughter second, or son, but we'll say daughter here. My spouse first, my daughter second. Now, if a lawyer is sitting across the desk from you and says, do you want your wife first and your daughter second? You'll say, sure. It sounds perfectly reasonable. What's wrong with it? Why wouldn't you do that? Yeah, I want my spouse first, my daughter second. We don't do that here at Ettinger Law Firm. We say, my spouse or my daughter. Why? Well, because the other way, if it says my spouse first and my daughter second, what happens if your spouse and you were in an accident? Or what happens if you need it, you're elderly, but your spouse is also elderly and maybe doesn't have his or her all her marbles? Daughter can't use it unless they can prove that mom can't, right? So daughter needs to do something for dad. The power of attorney says mom first, daughter second. Mom's not really with it, but daughter can't use it because she has to prove mom can't. She's the backup. How do you prove she can't? You have to go to a doctor, and the doctor has to examine mom and write a report and then issue a letter saying that they're unable to handle their legal and financial affairs. Well, will the doctor write the letter? Will the letter be clear and unequivocal? Will the third-party bank or investment house accept the letter? That's very, very hard to accomplish. So we like to be more practical. We say, my wife or my daughter. Well, I trust my daughter. I don't need to protect myself from my daughter. If she ever needs to use it, she could use it. And, as a practical matter, daughter doesn't have the document, does she? You have it in the house. Only your husband or wife can use it because they know where it is and their name is on it. With daughter, you say, look, if something ever happens and me and mom are not able, this is where it is in the house. Come and get it and do what you need to do. I like things that work in practice. And there's a lot of that. Our Medicaid Asset Protection Trust here, I wish all Medicaid Asset Protection Trusts were written like ours, because we put in the maximum amount of flexibility allowed by law. You need everything. You can't afford to miss anything. Do you need the right to change the trustee? Of course. I see irrevocable trusts all the time come in. The lawyer didn't write in a provision to allow you to change the trustee. Now a parent has a falling out, or they don't like how the son is handling it. They're stuck. So want to be able to change the trustee. I see lawyers write these Medicaid trusts without ability to change who you leave it to. Well, life changes, thing changes. You have to be able to change who you leave it to. Maybe you have a falling out with somebody. Maybe you gave somebody more. You want to even it up. They don't always have gifting powers. You need the power to make gifts. And a number of other things, but you want maximum flexibility and be able to do whatever the law allows. So I want your own plan for disability with your own people in charge for legal, medical, financial, and have your own elder law firm for them to go to, get the correct answers, and take advantage of whatever the law allows. Reason 9, it allows you to choose who will make medical decisions for you if you're unable to. You choose your end of life wishes. Most people, we find, want the same thing. If there's no hope of recovery and I have no meaningful existence, I want my family to be able to say when enough is enough. And we're not talking about assisted suicide here. We're talking about withdrawal of artificial life-sustaining treatments like feeding tubes, successive rounds of antibiotics, other extraordinary measures. So you'll state what you want. Now, and then you pick an agent to carry it out. You want to make sure that your agent understands they're not making the decision, they're carrying out your wishes. And then it's going to be stated in the document. Excuse me while I tend to allergy season. Comes when it comes. Authorizes your agent to get your medical records, because there's a HIPAA authorization, so they can determine the nature and extent of your issues, talk to your doctors. It prevents the hospital making the decision, as the hospital might have their own agenda. They might have you on life support and they're getting very well paid to do it. They may want to keep you there for longer than you would have wanted. So make sure that somebody can say no. And reason 10 gives you peace of mind. So once you have a plan in place with all the documents, trust, inheritance trust, health proxy, living will, power of attorney, cancel the old will, you feel relieved knowing no matter what happens to you, you have a plan for it. Not just you have a plan, but you understand the plan. So I have an expression I like to say, if you don't understand the plan, you don't have a plan. And a good number of people come in here and they have no idea what they have. So that's not a good plan. So we want you to understand it And once you understand it, and we go slow, so you have time to absorb the information, you feel very secure. Not only do you have the right documents, and you actually know what's going to happen and who's going to be in charge and how it's going to be handled, but you have this elder law estate planning firm, been around, probably the biggest, one of the biggest, we may be the biggest in New York State. You can get the right answer. We have very good people. Over the years, we've hired good experienced lawyers from other firms who were unhappy for whatever reason. And now I think we have just about the strongest staff in terms of knowledge and experience of any firm that does this type of work. But the point I'm getting at is you can pick up the phone, call us. We don't charge our clients for phone calls or emails. You call and you get the right answer. How valuable is it for the rest of your life to have that law firm on retainer, no charge, you're a client, email, call, get the right answer. Getting the right answer is what it's all about. And you can't really cast about for opinions when you have a disability situation or you have a Medicaid situation. No use going around and trying to get everybody's opinion and seeing what you can learn that way, because there's only one opinion that counts. It's the opinion of somebody who knows what they're talking about. Opinions are a different weight. You need an opinion from somebody who can give you the correct answer, an opinion with weight, with substance, not what your neighbor said or your friend said or what happened, in somebody else's experience. It won't help you. In fact, just the opposite. It leads you on down the wrong track. So you'll have a plan. And as I say, you have not only this firm, but our firm has a succession plan. We have 8 lawyers, and we have lawyers in their 40s, 30s, and 20s. My wife's in her 50s, I'm in my 60s. But we have a succession plan, so there'll always be an Ettinger Law Firm, heaven willing, and you'll always be able to get the right answer. We publish a law letter once a week. Keep a close eye on that, because we're watching those Biden law changes very closely, seeing what actually becomes law or proposed to be law. And we're helping a lot of people move assets these days who have significant assets, because, it looks like now or never with the Biden changes coming. The key to any estate plan, I think we're one of the very few firms in the country that do this. Excuse me. Is the free review every 3 years. Why do we have a free review? Because we want that plan to work when you need it, not when you wrote it decades earlier. So we want to see if there's any changes in your health, your assets, your family, births, deaths, marriage, divorces. So, people come in after 3 years. Not too many people need a change, but we renew the acquaintance, we're building the relationship. Eventually, by the time 9 or 12 years goes by, most people need some kind of change. Who's in charge, who they're leaving to, something else happened. That's legal work. Pay for an amendment to the trust, but we're talking hundreds, not thousands, and you're good to go. So we like the plan to work when you need it, not when you wrote it. Hopefully, decades earlier. We actually have saved thousands of people, countless thousands of problems with that. And when something happens to one of our clients, we know who they are. So, a bonus reason, there you go, our estate tax problem. Right now, the federal exemption, 11.7 million, not a problem for anybody. New York, on a roughly $6 million estate, your family can owe over $500,000 estate taxes, because New York has the fiscal cliff. If you go over the amount, which is about $6 million, they tax the whole estate. If you have a spouse and you set up 2 trusts, one for the husband, one for the wife, you can double the estate tax exemption, pass up to $12 million tax-free. Tax savings start at $500,000, go up to over $1 million, depending on the size of your estate. Look, I know the vast majority of people don't have $6 million or more, but I do want the people who have this to know about it, so they don't end up with a nasty tax they didn't know about. So Wednesday at 2 is our online seminar, 4 advantages of using trust. I'll talk about guardianship. I'll talk about avoiding probate. I'll talk about keeping in the bloodline, protecting the children's inheritance from divorces, lawsuits, and creditors. And I'll go into detail about the Medicaid Asset Protection Trust. It's Wednesday at 2 live. If you register at ettingerplan.com, Even if you don't watch it too, you'll get the recording an hour later, and you can watch it at your leisure, send it to your friends and family. Wednesdays at 2. Our unique planning process has begun with this seminar. We offer a free consultation where we ask you to bring in your will, trust, power of attorney if you have one, and we'll review it and tell you if it's legally adequate and discuss with you, is it personally adequate? Are these still the people you want in charge, or legal, medical, financial? Is this still the way you want to leave it, and who you want to leave it to? You get a copy of my book, Elder Law Estate Planning. We'll tell you which chapters apply to your situation. And we'll tell you if you decide to go forward, we don't really do business on the first meeting, but we tell people what they're looking at cost-wise. If you decide to go forward later on, this is how much it'll cost. Has nothing to do with the size of your estate, based solely on the type of work that you need according to our fee schedule. We prefer you come in for a second free follow-up consultation to have your questions answered. Come in for your second consultation, generally, 2 or 3 weeks later. We answer any questions you have about the first meeting of what we proposed and the what you read in my book, the chapters we've assigned to you, maybe an hour's worth of reading. At that second meeting, we draft the estate plan together with you. In other words, we ask you, who do you want in charge? How do you want to leave it? Who do you want to make medical? Who do you want to handle legal and financial? We draft the plan. At the end of that second meeting, we give you a detailed 2-page proposal in writing. Here's a number we mentioned the first time. Now it's in writing. What would you like to do? A lot of people say, it sounds good. Let's go ahead. And here we break with tradition. Ettinger Law Firm doesn't use a retainer agreement. I believe we're the only firm in the country that doesn't use a retainer agreement. We have a proposal. We sign it, you don't sign it. But our proposal says we're going to go ahead and prepare all these documents: trust, inheritance trust, power of attorney, health proxy, etc. You come in a few weeks later after everything is signed and done, you pay at the end. But unless and until you write us a check or you hand us your credit card, you have no obligation to the firm. You're free to walk away at any time. We do that to keep you, the client, in control. What we decided a number of years ago at Ettinger Law Firm is the retainer agreement was actually designed for the benefit of the lawyer, not for the client. In fact, it's not in the client's interest to sign a retainer agreement because you have to give the lawyer the check for half and you don't have anything, just a promise. And sometimes it doesn't pan out. The lawyer is slow, you don't like how the lawyer is handling it, or they make a mistake. And you can't get out. You already retained them and you're already giving them half the money. So we feel by keeping the client in control, it's the best place for you to be. And if we're here to serve you, and that's the best place for you to be, it must be the best place for us to be. And it's worked very well. We have today over 30,000 satisfied clients. So as I say, you come in for the final meeting, we review all the documents. After everything's signed, you pay at the end. And it could be by credit card or check, and it could be all at once or in 3 monthly installments. But then we don't say goodbye. The standard in New York and around the country, thank you, goodbye. Nobody ever hears the lawyer prepared their will. We say welcome. Now, we have a trademark process because we want it to work later on when you need it. Hopefully, you're not going to use it for a long while. So if there's law changes, you'll get that in my Elder Alert. We call it the Ettinger Elder Alert, comes by email. If you're on this broadcast, you'll start getting that. We review it every 3 years for changes in your health, assets, family, birth, deaths, marriage, divorces, etc. This way, oh, by the way, as I said, we don't charge for phone calls, emails, or questions. You have this firm on retainer for free. You can call us anytime, get the right answer. But by using this program, as I said, your plan is never more than 3 years old, designed to work when you need it, not when you signed it, hopefully decades earlier. As I say, you have thousands of people, countless thousands of problems. Nice thing is when something happens to one of our clients, we know who it is. We've always seen them within the last 3 years. So this short talk has generated a dozen questions. So let's go. I think we have one more slide. Yes, maybe one or two. And then we'll go into our dozen questions. We offer a free consultation. A lot of firms charge $500 for it. We don't charge. Still worth $500. With myself, could be Mrs. Ettinger, depending on where you are, or one of our experienced elder law planning, estate planning attorneys. They don't have any inexperienced ones, and they're all trained the same way. These days, more people are coming in. They just lifted the mask mandate, so a little more relaxed now. People are coming into the office. You could do it by Zoom to start off with if you like that. It could be by phone. In about an hour, within the hour, you'll get a copy of this presentation and also an invitation to use our link. It's called Calendly to make your own appointment. These appointments are very low key. You know, we're very low key here. We present the information, give you time to think about it, go on for a couple of weeks. You come back. The second consultation is free. Give your proposal. It's all up to you. You know, we really make it very easy for you. We go slow. We build your confidence. Make sure all your questions are answered, you understand. And then we proceed according to your instructions. Excuse me. You can call Patty Brown at the 800 number. Patty's been with us for more than 26 years, our Director of Client Relations. She can answer any question you have as well. Email her if you like, pbrown@trustlaw.com, or text free C, that's short for consultation, to the number on your screen. Now, with that, let's stop the share and let's go to those 13 questions now. So I'll repeat. Anonymous, right at the beginning, says, can a successor trustee change the terms of the Medicaid trust after you're deceased? No, they cannot. Anonymous also wants to know, can a nursing home take all the income from a trust? Well, yes, Anonymous, if the trust pays out the income to you. Now, we can create a no income trust. It doesn't pay you any income, in which case the nursing home will not get any of the income. So if you don't need the income, I could do a no income trust. Mario P says, if I choose 3 trustees and one is out of the country and never signs a document and expire before they return, what happens to them as trustee? Well, they're still a trustee. The question is, did you require the trustees to act together, or can they act separately? If they can act separately, it's not really an issue. If they have to act together, the one who didn't sign can sign after you expire, and the trust will be valid as of that time. Anonymous, if you set up a special needs trust for a child when they pass, can you direct where any of the remaining funds go to their, if you set up a special needs trust for a child, when they pass, can you direct that any remaining funds go to their child? Yes. If it's set up by a third party, you're a third party, you can say where it goes after they die. Absolutely, we do it all the time. Anonymous, how do you transfer property overseas to your children? We have a house in Italy, and I'd like my children to have it if they want it. Is this something you can do, or does this require a special lawyer? Well, as we all know, Italy is Roman law, and Roman law has this concept of patrimony, and it passes by law to your heirs. So I'm not sure that you have to do anything special. By law, when you die, it becomes theirs. Now, it wouldn't be a bad idea to simplify things if they want to keep the property to transfer to them while you're living. This will make it much easier after you're gone. They don't have to go through a process. Anonymous, can you set up endowments, foundations? I have experience with it, but I don't like to do it. It's too complicated and time-consuming, and most people don't have enough money to set up a foundation. It's just like a wish. I tell them, if you want to do something, contact the institution and use their charitable giving structures because they have it all set up. And so work through your college and maybe put a scholarship in your honor or something like that, or limit how they can use the money. Anonymous, is it possible to make a trust a beneficiary of an IRA? Absolutely. Do it all the time. You cannot put an IRA into a trust, but you can leave an IRA to a trust. You can name a trust as beneficiary, such as the inheritance protection trust you set up for your kids, to protect that inheritance from divorces, losses, and creditors. We're going to change the beneficiary in your IRA. Instead of leaving it to your children, we're going to leave it to your children's inheritance protection trust. Excuse me. That's allergy season. No, there's no tax consequences. Whether you leave it to a trust or to a person, it has to pay out over 10 years after your death under the Secure Act. Anonymous, if you have both revocable and irrevocable trust, can you transfer funds from the revocable to the irrevocable? Yes, you can, but there's 5 years on the new money when you transfer to the irrevocable trust. Anonymous, do you lose a New York Star exemption if you put your house in irrevocable trust? No. You keep your exemption, Star, enhanced star, veterans, you keep all those exemptions if the trust is done properly. I never lost an exemption in 30 years. Anonymous, is the estate tax limited based on the day you set up the trust or the date you die? It's on the date you die. Whatever the law is at that time is what governs. Anonymous, I'm living in South Carolina. Can your firm handle my estate plan? South Carolina, we cannot. However, I want you to take out a pen and write down this information. To find a good elder law attorney, you go to the website of the National Academy of Elder Law Attorneys, and that is NAELA, National Academy Elder Law Attorneys, NAELA.org. And if you go to the NAELA.org website, you can search for elder law attorneys by zip code. So you put in your zip code, and you could say, I want all the attorneys within 5 miles, or I want all the attorneys within 10 miles or 25 miles. You can scroll out. And my advice to people, which I'll share with you, is interview 2 firms. You don't need 3. Interview 2. You're clearly going to like one better than the other, and then you'll find your choice. If you don't like either of them, obviously, then you'll go to a third. Anonymous. Is any protection in trust for a beneficiary in case the grantor dies before the beneficiary will divorce? Does it help if he will create immediately a new trust? The question is not that clear, but you cannot put in a provision that somebody only gets it if they divorce. That's against public policy. Anonymous, what happens if you retire before I die? You mean if Michael Ettinger retires? Well, you know, old lawyers never retire. They just lose their appeal. But nevertheless, we have a succession plan. My wife and law partner is younger than me, but we have lawyers in their 20s, 30s, and 40s. We actually have a succession plan for Ettinger Law Firm, which the vast majority of estate planning and other law firms do not have because they're too small. They only have 1 or 2 lawyers, and that's it. I had an experience a few years ago. This client had an irrevocable trust. The lawyer retired, moved to Maine. And we needed to do something with the trust, but we didn't have the tax ID number. So I got a hold of the lawyer in Maine. I caught up with him. And it turns out he had Alzheimer's. He couldn't remember anything. He didn't remember where the trust was or the client or how to get the number. So that was the end of that. We had to rebuild it. So we have a succession plan here. An anonymous says, if you have a joint bank account with your kids and your name is first on the account, can you give above the gift amount to them without incurring gift or estate taxes? Well, you know, if your name is first, it has your social security number. It's actually all yours for tax purposes. They're just considered convenience signers. So they don't own half the account. So you can give, if you make a gift to them, it's, you're limited to $15,000 per person per year. If you go over that, you have to report the gift. There's no tax, but it comes off the amount you could leave at death. So it's a gift to them when they take money out in their name. So that's about it for today. I want to thank you all for attending. Thank you for listening to what I've had to say.